The First Amendment prohibits Congress from passing laws that abridge your right to petition the government for a redress of grievance. Yet not only has Congress ignored that restriction on their actions, but the federal courts have piled on as well. Today, I'll take a look at what the right to petition means, how it has been violated, and what the American people can do about it. Next on the Constitution Study.
There's one thing you have to know wherever you make your stand. Came from a long through line of everyday Americans.
Hello there, everyday Americans, and welcome to the Constitution Study, where we read and study the Constitution. We teach the rising generation to be free. I'm so glad you could join me today. As always, if you want to find out more, head to constitutionstudy.com. Everything I do kind of centers around that website. You can ask questions, you can sign up for the newsletter, you can find these videos, articles, all sorts of things right there on that website. And I'll talk a bit more about that later, but for now, let's talk about this right to petition. The right to petition, at its core, is pretty simple. Webster's 1828 dictionary defines petition as a transitive verb, to make a request to ask from, to solicit, particularly to make supplication to a superior for some favor or right. You have a right to request your governments for a redress of a grievance, to correct some wrong. This can be in the form of petitioning your representatives or seeking redress in a court of law. To understand both the breadth and importance of the right to petition, we must first delve into the concept of sovereign immunity. West's Encyclopedia of American Law defines sovereign immunity as a judicial doctrine that prevents the government or its political subdivisions, departments, and agencies from being sued without its consent. The doctrine stems from the ancient English principle that the monarch can do no wrong. The doctrine of sovereign immunity places those in government above the law by protecting them from lawsuits simply because they are or work for some government agency. The concept of, or at least the abuse of, sovereign immunity was one of the grievances given when the colonies declared independence, for protecting them by a mock trial from punishment for any murders which they should commit on the inhabitants of these states. Now granted, it was grievance number 15 out of 27, but it's there. The First Amendment included protecting this right to petition, but why? Because the principle of sovereign immunity is based on the principle that the sovereign cannot be wrong. In the United States of America, though, no one is supposed to be above the law. Now, the 11th Amendment is often used as an example of the states having sovereign immunity. However, this amendment did not prevent citizens from one state suing another state, only from doing so in federal court. As we read, "The judicial power of the United States shall not be construed to extend to any suit in law or equity, commenced or prosecuted against one of the United States by citizens of another state, or by citizens or subjects of any foreign state." Nowhere in the Constitution have I found a clause that would protect governments or government actors from being sued or prosecuted for any crimes they may commit. Even Article 1, Section 6 does not grant sovereign immunity to members of Congress. The senators and representatives shall, in all cases except treason, felony, and breach of the peace, be privileged from arrest during their attendance at the session of their respective houses, and in going to and returning from the same, and for any speech or debate in either house, they shall not be questioned in any other place. Members of Congress may still be arrested while in session for certain serious crimes, such as treason or felonies. And there's not a protection from arrest when they are not attending or going to or from their respective houses. This protection from arrest while working for the government is not granted to any employee of Congress or any of the other branches of government. Courts, on the other hand, have been more than happy to grant this illegal protection to government employees to the detriment of the people and the very concept of justice. Which leads us to the Supreme Court case Bivens versus 6 unknown federal narcotics agents. When studying the current jurisprudence regarding sovereign immunity in federal courts, the most common case cited is simply referred to as Bivens. In this case, Webster Bivens made the following complaint. Petitioner's complaint alleged that respondent agents of the Federal Bureau of Narcotics, acting under color of federal authority, made a warrantless entry on his apartment, searched the apartment, and arrested him on narcotics charges. All of the acts were alleged to have been without the probable cause. Petitioner's suit to recover damages from the agents was dismissed by the district court on the alternative grounds: 1, that it failed to state a federal cause of action, and 2, that respondents were immune from suit by virtue of their official position. The Court of Appeals affirmed on the first ground alone. See, the district court dismissed the case for 2 reasons. First, that it failed to show a federal cause for action, a right to seek judicial redress. And second, as federal agents, the respondents were entitled to sovereign immunity. The Court of Appeals agreed with the district court on the question of cause of action, but ignored the question of sovereign immunity. Now, since the Court of Appeals ignored the sovereign immunity question, so did the Supreme Court of the United States. Having concluded that petitioner's complaint states a cause of action under the Fourth Amendment, we hold the petitioner is entitled to recover money damages for any injuries he has suffered as a result of the agent's violation of the amendment. In addition to holding that petitioner's complaint had failed to state facts making out a cause of action, the district court ruled that, in any event, respondents were immune from liability by virtue of their official position. This question was not passed on by the Court of Appeals, and accordingly, we do not consider it here. The judgment of the Court of Appeals is reversed, and the case is remanded for further proceedings consistent with this opinion. So while both the Court of Appeals and the Supreme Court did not deal with the question of immunity, it was ultimately decided that, since Mr. Bivens did have a cause of action, he could sue for damages. Since the question of immunity was ignored by these courts, it has not only survived but been modified by 2 rather interesting court cases. The first of these cases is Butts versus Economou. In his case, Economou sued federal officials after claiming that the Department of Agriculture instituted illegal proceedings against him, violating several of his constitutionally protected rights. Both the district court and the Supreme Court agreed that while federal officers are not entitled to absolute immunity, they are entitled to qualified immunity. Now, the Free Legal Dictionary defines qualified immunity as, in the United States, qualified immunity is a legal principle that grants government officials performing discretionary functions immunity from civil suits unless the plaintiff shows that the official violated clearly established statutory or constitutional rights of which a reasonable person would have known. Now, in Nixon versus Fitzgerald, Mr. Fitzgerald lost his job as a management analyst with the Department of the Air Force after testifying before a congressional subcommittee. Mr. Fitzgerald filed a complaint with the Civil Service Commission, which was rejected. Mr. Fitzgerald then filed a suit in federal court against several Department of Defense officials, then amended the complaint to include Richard M. Nixon, who was President of the United States at the time of his termination. Now, the Supreme Court found petitioner, as a former President of the United States, is entitled to absolute immunity from damages liability predicated on his official acts. The court went on to explain that while there is no blanket recognition of absolute immunity for federal officials, certain officials, such as judges and prosecutors, required an absolute exemption from liability, meaning that while these officials did not have absolute immunity for their actions, they did have immunity from federal lawsuits. Furthermore, the court noted that due to separation of powers, the president had absolute immunity due to his office. The court also noted that absolute immunity was limited to his actions within the duties of his office, and that there were other mechanisms such as impeachment to redress presidential misconduct. Now, one thing to remember is that these cases deal with immunity from civil suit, not criminal prosecution, and only for actions taken within the boundaries of their official duties. But what happens when Congress flagrantly violates your right to petition government for a redress of grievance? Enter the Public Readiness and Emergency Preparedness, or the PrEP Act. Of the many illegal acts committed by governments at all levels in response to COVID-19, one of the most egregious was Congress's attempt to abridge your right to petition your government for a redress of grievance, at least when it came to the question of vaccinations. From Title 42, Section 247-6D, which is called the Targeted Liability Protection for Pandemic and Epidemic Products and Security Countermeasures, we read, Subject to the other provisions of this section, a covered person shall be immune from suit and liability under federal and state law with respect to all claims for loss caused by, arising out of, relating to, or resulting from the administration to, or the use by an individual of a covered countermeasure if a declaration under subsection B has been issued with respect to such countermeasure. In English, those who manufacture and administer certain covered countermeasures were immune from lawsuits. If you are injured by one of these products, say an mRNA vaccine designed to prevent the spread of COVID-19, you could not sue the manufacturer, the employer who coerced you into taking the shot, or the person who failed to inform you of the possible side effects. Even though it's against both federal law and medical ethics to use coercion, failure to inform the recipient of possible side effects, and of the fact that they can decline treatment in an attempt to get someone to take a product released under an emergency use authorization. Congress claims to have given those involved blanket immunity for their criminal acts. Or have they? You see, the First Amendment to the Constitution states, Congress shall make no law abridging the right of the people to petition the government for a redress of grievance. Congress is forbidden from making a law that abridges your right to petition the government for a redress of grievance. That means that Section 247-6D of the PrEP Act is repugnant to the Constitution. And according to the Supreme Court of the United States, that means this law is void. From the opinion on the Marbury versus Madison case, certainly all those who have framed written constitutions contemplate them as forming the fundamental and paramount law of the nation, and consequently, the theory of every such government must be that an act of the legislature repugnant to the Constitution is void. So what does this mean to all those who have been injured, either by these vaccines or by the coercion to participate in a medical experiment, and believe they have no redress? Well, for one thing, it shows the importance of John Jay's admonition. Every member of the state ought diligently to read and to study the Constitution of his country and teach the rising generation to be free. By knowing their rights, they will sooner perceive when they are violated and be the better prepared to defend and assert them. See, by knowing your rights, you can see this act of Congress is legally meaningless. It's another tool we can bring to bear if and when we exercise our right and seek the redress that Congress wishes to deny us. It's the preparation to both defend our rights and assert them when those in government wish to deny them to us. Whether that person be in Congress, the president, a judge, or an agent of government, we need not only know what our rights are, but how we can defend them. If we wish to be citizens in a free republic, then we must stand when those who have been charged with defending our rights instead trample them. Unless you wish to live as a subject of a tyrannical government, one which acts as if those who work for it cannot be wrong, then we must join together and assist those who have been both injured by these drugs and denied their right to petition for a redress of grievance. Congress, the president, and indeed governments and employers at all levels have broken the law. Who will be the first to pick up the sacred fire of liberty and make a stand? And how many of us will stand with them? I've heard a lot of talk about the immunity clause in the PrEP Act, about the fact that they have blanket immunity. You can't sue them. But that's not true. The Constitution supersedes the PrEP Act, and the Constitution says Congress had no legal authority to pass that section of the PrEP Act. Therefore, it's void. It's meaningless. And I'm really hoping someone will start challenging this. I've reached out to several people whose stories I've heard and encouraged them to not only press for criminal charges, but to sue and push a court to recognize that the Constitution says Congress had no legal authority to pass that part of the PrEP Act. That is therefore null and void because it violates the Constitution, the very word of the First Amendment. As often as I point out cases that are not truly First Amendment cases, here's one right here. Everybody who's been denied the right to petition their government for a redress of grievance has a First Amendment claim. And that claim is against Congress and against the government of the United States. And it's about time we start doing so. Not just those who have been injured, but the rest of us need to stand with them as well. Show that we've read and studied the Constitution. We know what it says. We know what our rights are. And yes, we will defend them and we will assert them. And we will do them legally and legitimately. And we will not stand for those who refuse to do so. If you want a job in government, if you wish to be a public servant, and you refuse to follow the supreme law of the land, you're a criminal. And it's about time we start treating you that way. That means if you're in Congress, getting rid of you and finding someone that will actually uphold the Constitution. If it's the president, then it means voting for electors that will pick someone better. And if you're a judge, it means articles of impeachment. We shouldn't be afraid of these things. These are tools to control those in government. If we don't do it, who will? If we're going to sit back and depend on others to protect our rights for us, then we become their servants and their slaves. No, if you want to be a free citizen, it is time to stand up, assume the mantle of a free citizen, including the responsibility to hold people accountable, your elected officials and those in government who work under their auspices. Now, you can find out more. Again, go to constitutionstudy.com. You can find the text of this article. You can find all the links to prove your point. If you have a case and you've been told you cannot sue because of the PREP Act, I'd love to give you some ammo to help. Now, I'm not a lawyer. I can't give you legal advice, but I can read. And I'm more than willing to lend my expertise to you to help make a difference. Now, if you want to learn more about the Constitution yourself, I'm doing my online study. Go to constitutionstudy.com/study. You can find out more. You can try it for free. You get the first 3 sessions where we cover the Bill of Rights absolutely free. Find out more on the website. If you wish to participate, you can find out how to join right there. Again, that's constitutionstudy.com/study. Now, there are a lot of things you can do. There's a lot of things I can say, but here's the point I want to make. George Washington referred to the sacred fires of liberty. I also refer to the seeds of liberty, the seeds that we plant in human hearts, that yearning and desire to breathe free. Those seeds need to be planted. They need to be watered and cared for. So when the people recognize their rights are being violated, when their need to be free breaks through the fear that has been instilled in us by government and media and schools, well, then, once again, the American people can be part of the land of the free and the home of the brave. That's not going to happen until we, the people, take responsibility for the governments that we have created. So if you want to spread those seeds of liberty, take the articles, take my social media posts, take the videos. They're all free for you to use. Please share them. Help me spread the seeds of liberty to your family, to your friends, to your social media followers. Help us find out the truth, because it's the truth that will set us free. And hopefully it was worthwhile enough that you'll not only come back next time, but you'll bring a few friends to visit the Constitution Study.
There's one